Hello, and welcome to this month's presentation of Wake Up and Smell the Freedom. Tonight's topic will be the General Welfare Clause and the Necessary and Proper Clause of the Constitution. The General Welfare Clause is derived from the first paragraph of Article 1, Section 8 of the Constitution, and it provides that the Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States. It is then followed by the enumeration of 17 specific powers. Now, the issue with this clause comes from the question of whether the fact that the powers given to Congress have been enumerated as a restriction on this apparent grant of general power that we read in this first clause. Now, just a note, some have mistakenly alluded to the general welfare portion stated in the preamble of the Constitution, thinking that this is the section that deals with the General Welfare Clause. It does not. In fact, on Bill O'Reilly's The O'Reilly Factor, the email segment on July 5, 2013 had the question comment email, "Bill, you keep asking what the Republicans have to replace Obamacare. Under the Constitution, there is no role for the federal government in health care." To which Bill O'Reilly responded, "That's not true, Felicia. The opening paragraph of the Constitution says the welfare of the people must be promoted. A just healthcare system comes under that banner." Well, the problem with that statement is that preambles do not delegate powers. Preambles simply describe the ends that the document seeks to pursue. Now, the next clause that is also cited in this section as giving Congress extra power is the very last part of Article 1, Section 8, which states that to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States. Here's the best way to understand Article 1, Section 8, the General Welfare Clause, and its abuses. Imagine that the parents of a 17-year-old boy go out of town for a week, and they entrust him to take care of himself for that week. Before heading to the airport, the parents leave car keys, a debit card, and a note. The note reads, "Billy, you may use this card to withdraw money from the ATM, or use it as a check card to buy food, beverages, and gas, but only use our bank's ATM to avoid any fees. You may have bread, you may have milk, you may have fresh veggies, you may have fresh fruit, you may have lean meat, you may have fruit juice. You may fill the car's tank once. You may use the car when it's necessary to get the things on this list. P.S. You may not use the car or card for any purpose other than the purposes that we have stated." When the parents get home, they find the place a wreck. Empty pizza boxes, fast food containers, cigarette butts, and beer bottles are all over the place. They also discover half a dozen passed-out teenagers, and the whole place smells of marijuana. The parents find Billy and demand an explanation. Billy pulls out the note and says, "You wrote that I could buy food." "Well, pizza, burritos, and cheeseburgers are all foods." "You wrote that I could buy beverages. Beer and whiskey are beverages." "Gas could be open to any interpretation. Cigarettes and pot give off a gas." "You didn't write that I couldn't use the card to buy food, beverages, and gas for all my friends as well." "Don't worry, I only used the card and car when I deemed it necessary, like when I took a bunch of my friends to buy candy and popcorn at the movie theater every night, and hot dogs at yesterday's Yankees game." Now, you might be thinking, well, this is kind of an exaggeration. He is a kid and doesn't know any better. Or he is just a disobedient son. But that same kind of circular logic is the exact same reasoning and honesty that the federal government uses when it uses the general welfare or the necessary and proper clauses as excuses to commit unconstitutional acts. So real quick, before we get into those two clauses, let's give a recap of last month's presentation on the Commerce Clause. We learned that the Commerce Clause was greatly expanded under the court case of Wickard v. Filburn in 1942. But here's a quick summation of it. Because Roscoe Filburn grew his own wheat, he didn't buy any wheat. Because he didn't buy any wheat, it might influence others to not buy wheat. And if others didn't buy wheat, then that could cause wheat prices to fall. And if wheat prices fell, that would affect interstate commerce. And that effect on interstate commerce would exacerbate the Great Depression. So, for that reason, the federal government deemed that it had the authority to regulate the amount of wheat Roscoe Filburn produced on his own property. We also learned that because of this case, it effectively moved the goalposts on the power of the federal government. Wickard versus Filburn was the new standard for how far the government could intrude into our lives. Since it was interpreted so broadly, there really isn't any limitation on what the federal government can regulate. Now, just like Wickard versus Filburn in 1942 expanded the federal government's powers under the Commerce Clause, There was another court case that increased the general government's power under the General Welfare Clause of the Constitution. The case was Helvering versus Davis in 1937. Here's the background. On November 12, 1936, George Davis, a stockholder of Edison Electric Illuminating Company of Boston, sued. He alleged that the Social Security tax was unconstitutional, and asking that the company be kept from paying it. The U.S. District Court for the District of Massachusetts upheld the tax, but the Circuit Court of Appeals reversed it. IRS Commissioner Guy Helvering asked that the case go to the Supreme Court. Now, this case, which preceded Filburn, but is also in a way connected to it, was heard when the Supreme Court faced the worst crisis of its history. Indeed, the most important thing about this case is the political context in which it took place. The time of this court case, and Wickard versus Filburn, by the way, took place during Franklin Roosevelt's New Deal. Now, for those that don't know, the New Deal was a series of domestic economic programs enacted in the United States between 1933 and 1936. They involved presidential executive orders or laws passed by Congress during the first term of President Franklin D. Roosevelt. The programs were in response to the Great Depression and focused on what historians call the 3 R's: relief, recovery, and reform. That is, relief for the unemployed and poor, recovery of the economy to normal levels, and a reform of the financial system to prevent a repeat depression. Franklin Roosevelt's New Deal was immensely popular with the public. People were clamoring for the government to fix things, and because of this, Roosevelt dominated the lopsidedly Democratic Congress. Only one thing thwarted Roosevelt, and that was the U.S. Supreme Court. 4 justices, George Sutherland, Willis Vandevanter, Pierce Butler, and James McReynolds, believed that the Constitution should be interpreted conservatively, according to the intent of the framers. In their view, the federal government could not intervene in economic or local matters. And the 10th Amendment, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people, narrowly confined its legitimate activities. So the New Deal was overall invalid. Chief Justice Charles Evans Hughes and Owen Roberts often concurred. The liberal justices, Harlan Fiske Stone, Louis Brandeis, and Benjamin Cardozo, believed the Constitution had to be interpreted flexibly to meet changing circumstances. A clause in Article 1, Section 8, empowering Congress to impose and collect taxes, to pay the debts and provide for the common defense and general welfare of the United States, they believed authorized the New Deal programs. The Roosevelt administration feared that the court would rule that the Constitution did not permit federal tax-financed old age insurance. While the Social Security bill was still in Congress, the Supreme Court invalidated the Railroad Retirement Act, which resembled Social Security very closely. So the administration's allies on the House Ways and Means Committee weeded the insurance language out of the bill and physically separated the tax and benefits titles in the text so they wouldn't look like an insurance program. Meanwhile, the Supreme Court hammered the New Deal. On May 27, 1935, in a crushing defeat for Roosevelt, it voided the National Industrial Recovery Act and the Fraser-Lemke Farm Bankruptcy Act. It struck down the Agricultural Adjustment Act on January 6, 1936. The Guffey-Cole Act on May 18th, and the Municipal Bankruptcy Act, and a New York state law setting minimum wages for women on May 25th. Enraged, Roosevelt decided to subdue the court. His ego inflated by his 1936 landslide, on February 5, 1937, he abruptly asked Congress to enact a bill empowering him to appoint 1 additional justice for every one who turned 70 and did not retire, for a maximum of 6, thus enlarging the Supreme Court from 9 justices to up to 15. A firestorm ensued. Critics rightly called Roosevelt's proposal a plan to pack the court. Even liberals who deplored the court's decisions, including many congressional Democrats, opposed it. Its arm cruelly twisted by Roosevelt's threat to its independence, the Supreme Court began surrendering in self-preservation. On March 29th, the court upheld a revised Fraser-Lemke Act, the National Firearms Act, the Railway Labor Act, which promoted collective bargaining, and a Washington state law providing for minimum wages for women. Then cases arose involving the blatantly pro-labor Wagner Act and the Social Security Act. The court was in a hideous bind. Most of the justices opposed the expansion of government power which these laws entailed, but if they voided them, Congress would probably enact Roosevelt's court pack. On April 12th, the court upheld the Wagner Act. On May 18th, Vandevanter announced his imminent retirement, enabling Roosevelt to nominate a justice. And even though the case for Roosevelt's Social Security bill was weakening, he still would not quit and continued to dominate the Supreme Court. Such was the situation when the Supreme Court considered the Helvering versus Davis case. In fact, most all of the federal government's expansion under all of the clauses of the Constitution happened during Roosevelt's time in office. It was the most expansive time in our nation's history. So it was during this time of social and economic upheaval that the majority of things FDR did to enlarge the central government took place, but mainly with the cries of the American people to do it. Now, Thomas Jefferson stated in 1802, "Though written constitutions may be violated in moments of passion or delusion, yet they furnish a text to those who are watchful, that they may again rally and recall the people." And that's what we have to try to do. So what was the actual meaning of the general welfare and the necessary and proper clauses of the Constitution? Well, let's look at some of the facts surrounding these clauses to see if we can find the answer. While adoption of the Constitution was pending, some of the opponents made the charge that the phrase, "to provide for the general welfare," was a sort of legislative joker, which was designed in conjunction with the necessary and proper clause to vest Congress with the power to provide for whatever it might choose to regard as the, quote, "general welfare," unquote, by any means deemed by it to be, quote, "necessary and proper," unquote. The suggestion was promptly repudiated by advocates of the Constitution. In the first place, it was pointed out, the phrase stood between two other phrases, both dealing with the taxing power, an awkward syntax on the assumption under consideration. In the second place, the phrase was coordinate with the phrase, "to pay the debts," that is, a purpose of money expenditure only. Finally, it was asserted that suggested reading, by endowing Congress with practically complete legislative power, rendered the succeeding enumeration of more specific powers superfluous, thereby reducing the Constitution to a single phrase. Another contemporary assurance as to the limited scope of the General Welfare Clause is that was given by James Madison in Federalist No. 41. It has been urged and echoed that the power to lay and collect taxes, to pay the debts, and provide for the common defense and the general welfare of the United States amounts to an unlimited commission to exercise every power which may be alleged to be necessary for the common defense or general welfare. No stronger proof could be given of the distress under which these writers labor for objections than their stooping to such a misconstruction. But what color can this objection have, when a specification of the objects alluded to by these general terms immediately follows, and is not even separated by a longer pause than the semicolon? For what purpose could the enumeration of particular powers be inserted, if these and all others were meant to be included in the preceding general power? But the idea of an enumeration of particulars, which neither explain nor qualify the general meaning, is an absurdity. It is also very significant that as the progress of the Constitution through the Convention continued, at no point did the clause excite or cause anyone to comment. The explanation was furnished by Madison. Writing in 1830, he said, "These terms, copied from the Articles of Confederation, were regarded in the new, as in the old instrument, merely as general terms, explained and limited by the subjoined specifications, and therefore requiring no critical attention or studied precaution. It exceeds the possibility of belief that the known advocates in the Convention for a jealous grant and cautious definition of federal powers should have silently permitted the introduction of words or phrases in a sense rendering fruitless the restrictions and definitions elaborated by them." Jefferson rejected the view that the General Welfare Clause conferred additional power as well. He stated, "Distinct and independent power to do any act that they might please for the good of the Union would render all the preceding and subsequent enumerations of power completely useless. It would reduce the whole instrument to a single phrase, that of instituting a Congress with power to do whatever would be for the good of the United States. Certainly no such universal power was intended to be given them. It was intended to lace them up strictly within the enumerated powers, and those without which, as means, those powers could not be carried into effect." As to the necessary and proper clause, in Federalist No. 33, Alexander Hamilton wrote, "What is a power but the ability or faculty of doing a thing? What is the ability to do a thing but the power of employing the means necessary to its execution? And what are the proper means of executing such a power but necessary and proper law?" Madison stated that the clause gives no supplementary power. It only enables them to execute the delegated powers. For when any power is given, its delegation necessarily involves authority to make laws to execute it. And James Wilson said that the clause says no more than the powers we have already particularly given shall be effectually carried into execution. So there really is no way to misunderstand the meaning of the Constitution unless you actually don't want to understand the Constitution. It's very straightforward and laid out. Only powers listed are what Congress has. If it is not mentioned, Congress doesn't have it. What we have to do is educate others on the meaning and understanding of the Constitution. The thing to remember is all of Congress's power are outlined in Article 1, Section 8, and that's all they can do. There are no elastic clauses or loopholes or expansive or implied powers. All powers are enumerated and clearly laid out. And anything else that Congress does beyond that is unconstitutional and hence illegal. If you'd like to learn more on this subject, we encourage you to find and read the sources that we used for this presentation. The Federalist Papers, the records of the Federalist Convention, 1787, debates in the several state conventions on the adoption of the federal Constitution, Federalism, the Founder's Design. All of these can be found in the Dark Roast section of Smell the Freedom, or have links to help you buy your own copies.